the burden of proving his innocence. The Constitution has already declared him or her innocent under Article 28, Clause 3, Paragraph A. The burden is on those who are accusing him of committing an offense who must prove his guilt. It's not the other way around. Please, the lawyers in government departments, in particular the Attorney General, give proper legal advice to the head of state. Don't subject that office of the president to ridicule. The moment you don't discharge your duty of giving proper legal advice, a head of state will end up making statements that are illegal, that are unconstitutional, and shameful, and you bring the whole country under disrepute. The same Article 28 demands that an accused person must be informed, properly informed of the allegations brought against him. The entire evidence the state has against the accused must be put on table for the accused to understand. We are dealing with a case in which the state is relying on audio evidence, video evidence. Now, that requires the accused persons to watch those videos, listen to the audios, and discuss the contents of the same with their lawyers. That can only be done if the gadgets required to do that are made accessible to the accused persons. Court, the Honorable Land Justice Baguma Emmanuel, gave us permission to access Luzira prisons and review the entire evidence with the accused persons. Unfortunately, Uganda prisons did not allow us to enter into the prison premises with not even a pen, not even with a phone, for us to access the accused persons and review their evidence. Now at that point, how dare you say that the accused persons are aware of the offenses and they are aware of the evidence, therefore they should not delay the trial. Article 128, Clause 3 of the Constitution of Uganda demands that all agencies of the state, by agencies I include UPDF, I include Uganda prisons, all agencies are supposed to accord the courts such assistance as may be required to ensure effectiveness in the delivery of justice by the courts. Now, where a court has made an order allowing lawyers to access their clients with such equipment to enable them to go through the evidence, and you block them from accessing the accused persons, will you really have helped courts? Where courts are demanding the accused persons to produce their lawyers in court, and they proceed with the hearing, and you abduct the lawyers, will you have helped court? You will have breached Article 128, Clause 3. Therefore, Judge, if you are interested in a speedy, expeditious trial of Dr. Besigye, demand all the government agencies, all the departments, to remove their hands off the justice of the case. They should not interfere with the way the case is proceeding by arresting lawyers, by denying accused persons access to evidence, by intimidating the lawyers, by intimidating the judges, by hiding identities of witnesses. By doing all that, they are putting roadblocks on the way to justice and a speedy trial of the case. The other demand under Article 28 is that the lawyers, the accused persons, are entitled to legal representation. Legal representation of their choice. In their decision, Haji Rutale and Dr. Besigye mobilized legal services from within Uganda and outside Uganda. What happened has been expounded upon by the Vice Chair of PFF. Our lead counsel, Senior Martha Karua, was declared persona non grata, an unwanted person, and deported. At a time when we are campaigning for regional integration, at a time when we are encouraging mobility of labor throughout the region and beyond, surely the act we did of deporting Karua, how different is it from what is happening to our fellow Ugandans in South Africa? We demand that the persona non grata order should be rescinded. It should be rescinded so that Martha Karua and all the other lawyers across the borders can come and represent their clients. We demand that the entire legal team that's defending Dr. Besigye and Haji Rutale should be allowed to execute their duties unencumbered. Otherwise, the president will lose sleep that the case is not proceeding. Jaja, we don't want you to lose sleep because the right things are not being done.
Riding a bicycle but holding the brakes.
Now, you heard the accused person the other day lamenting that his mouth is closed, is with self-tape. The hands are tied, the legs are tied, and you are still demanding he should come and defend himself. Your Excellency, it's not a good idea to ride the bicycle while holding a Besigye'S. Release the clutch if you want the motorcycle to move. For justice to move, all the links within the chain of justice must freely move. And it is within the principles of our legal system that all benefits of doubts must go to the accused person. If the prosecutors are failing here and there, it is not for the president to descend into the arena of court to fill in the gaps. The same Constitution, Article 28, Clause 3, Paragraph G, demands that accused persons must be afforded the facilities and opportunity to cross-examine all the witnesses without limit. Dr. Besigye, Haji Rutale have already indicated that they want to cross-examine General David Muhoozi, CDF, in the matters that are pending before court. If the president wants the case to move very fast, should accompany the son to court, they invite Besigye, bring your lawyers, unencumbered, and they cross-examine the witness. Because that's the command of the Constitution. I would also like to bring the attention of Jaja, Article 208 of the Constitution of Uganda about UPDF. Clause 2 of that article is so pivotal. It says, the UPDF shall be non-partisan, national in character, professional, disciplined, productive, and this is very important, and subordinate to civilian authority. UPDF is supposed to be subordinate to us. It is not us who are supposed to be subordinate to them. Bapaka Sibafe. UPDF is not supposed to be partisan. It's not supposed to be in bed with PLOU, in bed with NRM, because it is supposed to be national in character and non-partisan. Therefore, given the fact that UPDF is supposed to be partisan, it should not be misused in pursuing personal scores. Now, the Baganda say, Ediokanga netonya, etulabe ensisira bwezenkanya emyoyo. There's no such Chinwachebe who said, unless the wind blows, you can never see the vent of a hen. Had it not been for this case of Besigye, we wouldn't have seen UPDF abducting lawyers. Now, the question follows, is UPDF still non-partisan? Is it behaving professional? Is it subordinate to civilian authority? We pray, we demand that UPDF, as the late Christopher Chiombo said, should go back to the Constitution, should go back to Article 208. Article 1261 of the Constitution of Uganda provides that judicial power is derived from the people and shall be exercised by courts in accordance with the values and norms and aspirations of Ugandans. So these courts are not a private instrument of Jaja. These are state institutions. They are supposed to act independently. They are supposed to administer justice irrespective of social, economic status of those who appear before them. And Article 128 guarantees independence of the judiciary. Now, talking about independence, the independence goes to another level. Not even a Chief Justice can order a trial judge to act in a particular way when he's handling a matter. A judicial officer is supposed to act independently, without any interference from any other quarters. Now, for Jaja to say that bail should not be granted is a contravention of Article 28, which guarantees the right to apply for bail.